Hello, this is Professor Donna Byrne, and this is Estates and Trusts Online Module 7A. We're talking about marital property rights. Okay, in this set of videos, the first two cover these objectives. And the first one, we will explain how community property functions to guarantee each spouse part of the couple's property holdings, and we'll describe ways in which separate property could be reclassified as marital property. In 7B, we'll distinguish between marital property ownership and spousal inheritance rights, and we'll also identify some of the limitations of traditional elective share statutes. Okay, so community property. We've heard about it. What is it? Community property is about ownership. It's about each spouse owning half of all the money and property earned or acquired during the marriage. Mine. And then when the first spouse dies, it's kind of like joint tenancy in a way. The other spouse already owns something. In this case, the other spouse owns 1/2 of the community property. Already mine. Unlike joint tenancy, the surviving spouse doesn't get the whole thing. And that means that each spouse could choose to leave his or her half to someone else. In addition, spouses could have separate property that they owned before the marriage, or separate property that they acquired during the marriage. Okay, you read in Ray Kobylski. This is a Wisconsin case. Wisconsin is a community property state. Minnesota, by the way, is a separate property state. In Wisconsin, question here is, when does separate property become community property? And there's a statute that applies that says something along the lines of, when substantial labor, efforts, and marital cash are applied during the marriage and tracing is not possible, perhaps because unreimbursed labor is involved, then we can reclassify marital property or separate property as marital or community property. Okay, so in this case, Genevieve came into the marriage with a house. Genevieve and Geza were married for about 8 years, and Genevieve had a will executed before the marriage that left everything to her kids from a previous marriage. When she died, Geza argued that he should get half the value of the house. Okay, so how does property get reclassified? Well, it could be reclassified because the spouse who owns it gives half of it to the other person or gives it to the community. Or it can get reclassified through mixing. Okay, if that's it, Geza is the one who has the burden of proving that there was mixing and also that tracing was not possible. So what do we know? We know they paid together about $4,000 for repairs and improvements from their joint funds. That's mixing. But is it traceable? Well, sure. I mean, the fact that they can list the expenses shows pretty clearly that it is traceable. So the marital estate is entitled at least to reimbursement. That means that we're going to say that, yeah, the marital estate has contributed value to Genevieve's separate property, and so we treat some of that value as marital, and the marital estate is the part to which Geza is entitled to half. But how much reimbursement? The amount of money contributed or the value of the improvement? Well, the court says enhancement in value is the thing that matters. So that means that expenditures that relate merely to the maintenance of the property and do not enhance its value are not to be considered. Okay, there's a second thing going on, a second kind of mixing, and that's mixing of industry. What's industry? It's effort. So if he puts a lot of effort into the property and doesn't get compensated, that can be a kind of mixing. Application by one spouse of substantial labor, effort, inventiveness, physical or intellectual skill, creativity or managerial activity to either spouse's property other than marital property creates marital property. If what? Let's see. if there's no reasonable compensation and substantial appreciation in value results from the application. So what did Geza do? Well, he did apply substantial labor. He received no reasonable compensation, but did his efforts produce substantial appreciation? Because if so, then the separate property, while it may not be reclassified, the increased value at least is marital property. So the question is, did he create increased value, or did he just kind of do, the kind of maintenance that, as my relatives say, that's what the guy does? Court remands to find out how much value was added and how to value the increase in marital property. But they do say we don't reclassify. There wasn't enough to reclassify because we could trace the contributions of money. Okay, so community property, again, is half and half ownership of the marital estate, and separate property can become reclassified if it's mixed together with marital property. In addition, uncompensated efforts can create marital property, or the surviving spouse could be reimbursed when separate property is not reclassified and no marital property results from the efforts. Oops, wait a minute, go back to that one. I'm sorry about that, folks. Okay, so community property, again, means the survivor owns half the marital estate. Separate property can become marital through gift or mixing, and uncompensated effort creates marital property if it creates substantial new value. I'm sorry that I'm half in shadow here. We'll continue this in Module 7b. This is a surviving hedgehog. Thanks for watching.